Welcome back to our channel, Just Immigration News. Undocumented parents must act now for the future of their children. Please hit like and subscribe and for an upcoming video. Across California, countless families live with the quiet fear that immigration enforcement could separate parents from their children with little warning. For mixed-status families, this is not a distant concern, it is a real and pressing risk. Yet far too many parents delay planning, often due to fear, misinformation, or lack of access to proper legal guidance. Preparing for a potential separation is emotionally painful, but failing to plan can expose children to far more severe consequences. For families facing immigration uncertainty, proactive legal preparation is not optional, it is essential. A lesson from the past, when good intentions lead to long delays. Years of experience at the crossroads of family law, guardianship law, and child welfare reveal a troubling pattern. Families often act too late. In one heartbreaking case, a mother was deported during the first Trump administration and separated from her young child at the border. When a later federal program allowed some separated parents to return, she seized the opportunity. However, due to earlier legal decisions made without full awareness of long-term consequences, her reunification process stretched on for years and cost thousands of dollars. Even though everyone involved agreed she was a fit and loving parent, reversing prior legal actions proved painfully complex. This case underscores a critical truth: early decisions matter, and mistakes can echo for years. Start with the right legal support. The single most important step parents can take is to work with a licensed attorney who understands California family law. Immigration issues intersect deeply with state custody laws, and not every attorney is equipped to navigate that overlap. Parents must also remain vigilant against fraud. In California, some individuals falsely present themselves as notarios or legal advisors. Unlike in many countries, notaries public in the United States cannot practice law. Trusting the wrong person can result in invalid documents and devastating legal consequences. Understanding what does and does not work in California. A common misconception is that a power of attorney can transfer parental authority. In California, this is simply not true. A power of attorney cannot grant custody or parental rights, no matter how well-intentioned the arrangement may be. Parents who rely on this option risk leaving their children legally unprotected. In reality, there are only two lawful paths available: a caregiver affidavit or a formal guardianship. Caregiver affidavit, a practical first line of protection. For most families, a caregiver affidavit is the safest and most flexible option. This document allows a trusted adult, often a relative, to handle daily responsibilities, such as enrolling a child in school, signing educational forms, and arranging routine medical care. However, it has limits. A caregiver cannot obtain a passport, authorize major medical procedures, or remove the child from the country. Still, for short-term or uncertain separations, this option preserves parental rights while ensuring children remain cared for. Guardianship, a powerful tool that requires caution. Guardianship transfers full parental authority to another person, but temporarily suspends the parent's legal rights. While this may seem like a strong safety net, it comes with serious risks. Ending a guardianship requires a formal court process, even when all parties agree and the arrangement was meant to be temporary. Parents often assume family members, such as grandparents or aunts, will easily return custody. In reality, many parents face prolonged legal battles and some never regain custody at all. Guardianship should only be pursued with thorough legal advice and full awareness of its long-term impact. Doing nothing is the greatest risk of all. Failing to plan can trigger intervention by Child Protective Services. Without legal documentation, children may enter foster care, where timelines move quickly and reunification becomes far more difficult, especially for parents who are detained or deported. In extreme cases, parental rights may be permanently terminated. A call to action: protect your family today. If you are at risk of deportation, planning ahead is an act of love and protection. Speak openly with trusted family members. Decide who could care for your children if needed. Prepare a caregiver affidavit or explore custody options with a qualified attorney. This is a frightening reality, but preparation offers power, clarity, and peace of mind. Take action now, your children's future depends on it. That is all for today in this video. See you later in the next video. Till then, take care.